The purpose of this webinar really is VACO and VML, in cooperation with the Office of Attorney General and outside counsel from litigating jurisdictions, have put together this webinar just for you all today so that you can learn more about the opioid settlement distribution. We know that there are lots of questions, and there is lots of money that will be coming into Virginia. Know that our county administrators and city managers and town managers need to be aware of all this incoming money and how it's to be distributed. So that being said, let me. All right. Mute. Thank you. And let me introduce the panelists we have speaking for today. We have Sam Towell, who is the Deputy Attorney General for Civil Litigation with the Office of Attorney General. We have Richard Schweiker, the Senior Assistant Attorney General and Chief of the Consumer Protection Section with the OAG. We also have Tom Beshere, Assistant Attorney General. And we also have with us Delegate Terry Kilgore. I think he'll be joining us just a little bit later. We have Tim Spencer, who is the City Attorney for the City of Roanoke and a board member of the Virginia Opioid Abatement Authority. We have Leo Rogers with us, who is the County Attorney for the County of Loudoun. We have Ed Spivey, a member of Kaufman and Canoles in Norfolk, Virginia. And we have Burton LeBlanc, who is the shareholder and of Barron and Budd out of Dallas, Texas. And we thank all the panelists for being on here today. And we will help you unmute if you are having trouble, but wanted to welcome you all with us today. Let me quickly just kind of go over the agenda today and what we're going to be doing so that everyone will know. We're going to be looking at VACO and VML will be discussing our monitoring of the opioid litigation and associated local government interests. We'll also be looking at the history of pending distributor settlements, which is Jansen settlements, and the call for action. We'll also be discussing the Virginia Opioid Abatement Fund and settlement allocations. We'll also be talking a little bit about the Virginia Opioid Abatement Authority and the logistics for participation in the settlements, which is the MOU. We'll also be talking about the multi-district litigation and the Virginia State Court litigation update. And we'll be answering questions at the end of each presentation. I would ask that you hold your questions until the end. But if you just got a burning question, put it in the chat. And that's how we'll be addressing. That's how the panelists will be addressing all the questions. We have with us our VACO team: Phyllis Arico, Gage Harder, and let's see. And I think
Katie Boyle.
Katie, yes, okay. Katie, I don't see Katie on here, but I know she's there somewhere. And Katie Boyle will also be with us, and we'll be monitoring the chat and asking questions from the panelists after they finish. So with that being said, let me turn it over to Phyllis Arico. Phyllis is our general counsel, and with Phyllis also is Josette Bulova from Virginia Municipal League. Phyllis, you're on.
Thank you. You know, we all know that this opioid crisis has hit Virginia hard, and VACO and VML have been monitoring it and sending information to our members for, I think, 5 or 6 years now. Some localities engaged counsel to file suit, while others did not. As Dean mentioned, today we will be discussing a settlement agreement that can benefit all Virginia localities. One thing I will stress is that this is a short time frame. Each non-litigating locality has to do a number of things, and they have to do it before January 2nd. And you're going to hear more information about what you need to do and how you need to do it as this panel progresses. At this point, I just wanted to ask Josette, do you want to say hello from VML?
Yes. Good morning, everyone, and thank you to the panelists and VACO for having us. I just want to copy exactly all of Phyllis's sentiments. Just say that VML is here and we are monitoring this very closely, and we will do some follow-up, and we're here if you have any questions that you'd like to ask. Thanks.
Thank you, Josette. And Sam, I think we're going to turn it over to you and the other members of the Attorney General's office to move forward with the agenda.
Thank you, Phyllis. I really appreciate it. And thank you also, Dean and members of VML and VACO for assembling this large group so that we can really push the issue about disseminating information about this upcoming settlement to make sure that we maximize Virginia's recovery and recovery for our individual localities to help all Virginia residents with what is an unprecedented healthcare crisis. Is there someone who can bring the slide deck up to the screen? Wonderful. And if we could scroll up to the first slide.
Can you all see that first slide?
I believe this is a slide in the middle of the deck that I can see. I believe it's slide 5.
Okay, I apologize. I don't know why this is not going to the first
That's the
slide.
first slide. Wonderful.
Okay.
And if we can go to the next slide, please. There should be one in, but there we are. So before I get into some of the background, I want to make sure to address the most important piece with respect to this particular gathering. And that is the settlements that are on the table within the framework of the multi-state dynamic that involve 3 primary distributors and the manufacturer Jansen, wholly owned by Johnson & Johnson. This settlement involving 4 defendants or targets has an overall price tag of $26 billion. Approximately $530 million of that settlement fund is potentially available to Virginia, that is the Commonwealth of Virginia, and its constituent city and county localities, but only if the maximum number, that is to say all cities and localities, both join the Memorandum of Understanding with the Commonwealth of Virginia and enter into the settlement agreement that it underpins this particular settlement with these 4 target defendants. So again, I cannot stress enough that the amount of recovery very much depends on the participation of the localities, both those who have filed suit and those who have not filed suit. Entering into the settlement agreement is the only way to maximize funds that can flow to the Commonwealth of Virginia and its localities. So of this $530 million, the individual defendants are, again, Jansen, which is a subsidiary of Johnson & Johnson, Cardinal, McKesson, and AmerisourceBergen. Those 3 other defendants are distributors of a host of medical products, but in particular with respect to this litigation, the primary distributors of opioid products over the last several years. So these funds will be distributed to the localities and to the Commonwealth over an extended period, that is 18 years with respect to the 3 distributors, and 9 years with respect to the manufacturer Jansen. However, this is largely front-loaded, so early years will see a greater than average outlay, and the tail, which is rather long, does provide for a consistent funding stream for a number of programs that localities, regions, and the Commonwealth may develop. And again, the sign-on for this particular settlement is January 2nd of next year. And so we very much encourage all localities to take those steps necessary with their governing boards in order to join both the Memorandum of Understanding, which we will talk about here briefly, and the settlement document itself, which we will also again explain in greater detail here in short order. The next slide, please. I think it's also important to note that this settlement, while large, is not the only one that is in the works. Our office has been involved in investigations with respect to the opioid crisis in a meaningful multi-state way since I got here almost 5 years ago, starting around February of 2017, in earnest with a number of our other state partners. But a lot of the work had been done even before that. Of course, as the Commonwealth, we do not need to file suit in order to engage in pretty meaningful investigations and discussions with potential targets. And so while a number of localities have identified a number of potential defendants in suits that they have filed, we have been engaged in investigations with a number of companies for some time. One of those, the McKinsey settlement, has already been entered into by the Commonwealth. That settlement of about 13.7 million, of which 11.3 million is currently sitting in escrow, was designed primarily to just between the Commonwealth and and McKinsey itself as part of a multi-state agreement. However, the Commonwealth has turned those funds over to the Opioid Abatement Authority, about which you will hear more later, to provide effectively seed money for that authority. There are two cases that are currently engaged in bankruptcy proceedings. One, Purdue Pharma, against which the Commonwealth did file suit. That bankruptcy case has been going on for some time. And while there is a plan that I believe is currently being proposed to the court in that case, we do expect that to take some time, as that is a particularly contentious bankruptcy involving not only the Purdue Pharma company itself, but also the Sackler family, of which I believe most on this Zoom may be familiar, the family that has been in the driver's seat of Purdue Pharma for some time. The second case, which is not as contentious in a lot of respects, involves the Mallinckrodt Company, another manufacturer of generic opioids. We expect that bankruptcy process to wrap up in advance of the Purdue bankruptcy, and will likely be an early opportunity for additional funds to flow to states and localities. The Commonwealth of Virginia has also independently filed suit against Teva involving some heritage products from Teva and Cephalon. That case continues apace in the Richmond City Circuit Court, but that is also part of a larger multi-state investigation and initiative. And then, of course, there are other investigations of which the Commonwealth is a part, which we are not at liberty currently to disclose, but that could involve other manufacturers, other distributors, other retailers, and other consultants and other companies involved in creating and exacerbating the opioid crisis. And I'll turn it over to my colleagues, Rich Schweiker, the head of the Consumer Protection Section, and Tom Beshere, an Assistant Attorney General who focuses on opioid litigation, for the next couple pieces. Thank you.
Great, thanks, Sam. If you can move it on to the next slide, please. So as actually it's a slide before that. There we go. Great, thanks. So as Sam indicated, Tom Beshere and I have been working on these matters. We actually have a team of attorneys in our Consumer Protection Section who have handled these investigations and the litigation that we filed. And well in advance of these settlements that we're talking about today, we anticipated the need to work with the litigating localities, so that the counties and cities that had filed suit on their own, regarding the allocation of any funds that we might recover in any settlements. So our office, on behalf of the Commonwealth and outside counsel representing the litigating localities, negotiated terms for the use and division of any settlement funds that we might get, in anticipation of these settlements, as well as others that might come to fruition in the matters that Sam referenced. So those negotiations resulted in the Virginia Opioid Abatement Fund and Settlement Allocation Memorandum, of understanding, or the MOU, which we're going to be referring to the MOU. So in a nutshell, the MOU provides for how settlement funds can be used. It allocates the funds in certain percentage shares. And it also served as the basis for legislation that passed the General Assembly earlier this year to create an opioid abatement authority and an opioid abatement fund. And you can see on the slide the statutory citations for that legislation. The MOU also provides for the payment of the litigating council's, the litigating localities outside counsel who have contingent fee contracts. Now, wanted to let you know that the MOU has been approved and signed by the Attorney General. It was signed back in August of this year. And my understanding is that there are approximately 80 localities that have approved and joined the MOU. Next slide, please. So here's how the MOU allocates settlement funds among the Commonwealth and participating localities. And so a participating locality would be a locality that joins the MOU and agrees to the terms of specific settlements. So here you can see that 15% will go to participating localities without restriction, meaning the money can be used for anything, but there are some exceptions to that, which I'll come back to. 15% also an additional 15% goes to participating localities to be used for opioid abatement purposes. And opioid abatement purposes are defined in the MOU and in the state statute very, very broadly. So the quote is, it's defined as any efforts to treat, prevent, or reduce opioid use disorder or the misuse of opioids, or to otherwise abate or remediate the opioid epidemic. So it's very, very broad. You'll see if you look at the MOU and the statute, there are actually 10 specific non-exclusive examples of such efforts, of things that can be done to abate or remediate the opioid epidemic. But again, those specific items in the MOU and in the statute are not exclusive. Then an additional 15% goes to the Commonwealth, also without restriction, but there are some exceptions to that as well, which I'll come back to. And then 55% of funds recovered in settlement will go to the opioid abatement fund that was created by the legislation that I previously referred to, that's referenced in the MOU. Now, with regard to the exceptions on the unrestricted shares to the participating localities and the Commonwealth, it's important to keep in mind that this MOU is intended to apply to a variety of potential settlements, and not just the ones that we're talking about today. So if a settlement requires that all funds be used for abatement, then the MOU recognizes this and basically provides that the Commonwealth and the localities will adhere to any such requirement. So if all the funds have to be used for abatement, the MOU recognizes that. So that's part of the caveat there. Now, with regard to the distributors and Jansen settlements that we're discussing today, it's our understanding that generally speaking, if funds are not used for abatement or remediation, the recipient of those funds will need to report how the funds were used. There are also some requirements that about 85% of the settlement funds being distributed under the national settlements must be used for abatement or remediation. But it's also our understanding that these funds can be used as reimbursement for past remediation. So you could take funds and allocate it based on the fact that there were prior expenditures for opioid abatement or remediation, and then those funds would not have to be used prospectively for abatement or remediation. Now, I'll say these settlements or agreements are very lengthy. It's still a settlement framework that we're working under, and there are some confusing provisions that may on their surface appear to conflict with one another, and we've been working through those issues with the multi-state leadership group that's negotiated these settlements. And there's some language indicating that localities that had not filed suit, that all of their funds may have to be used for abatement. Now, again, because of what I said earlier, that abatement funds can be used to reimburse a locality for past expenditures, there is a good bit of flexibility there, even with that restriction. Now, in addition to dividing funds between the Commonwealth and participating localities and the Opioid Abatement Fund, the MOU also allocates funds among the participating localities. So it includes a chart that provides the percentage share of each locality. Now, these percentages were provided to us by the litigating localities, and they were calculated using a formula or a methodology that was developed by a UVA professor, and it was based on various factors to assess opioid impact in the localities. So those factors include opioid deaths, opioid-related emergency department visits, the volume of prescription opioid products shipped to the locality, and it also includes a factor for whether the locality pursued litigation claims. Finally, the MOU includes provisions regarding the payment of outside counsel for the localities who filed suit. So the MOU provides that those counsel are first to seek compensation through a national attorney's fees fund, and the settlements we're talking about today did create a national attorney's fee fund. Now, if that national fund is insufficient, the MOU provides for a deficiency fund that would draw on the locality shares of the settlement funds. And under these provisions, outside counsel fees or contingent fees are capped at 25%, and they're specifically capped at 25% of the funds that are allocated to participating localities. And this payment would be shared by all of the participating localities. So next slide. So while negotiating and drafting the MOU, we prepared legislation to create the Opioid Abatement Authority and the Opioid Abatement Fund. And as noted on the prior slide, 55% of the funds, settlement funds recovered, will go to the Opioid Abatement Authority to distribute. But I wanted you to see this slide, which shows you how those funds are to be distributed by statute. So this is a breakdown of the 55% of any settlement funds that will go to the Opioid Abatement Authority to distribute. And I'm not going to talk a whole lot about the Opioid Abatement Authority because Roanoke City Attorney Tim Spencer, who serves on the authority, is going to talk a little bit more about that. But before turning to that, I did want you to see these percentages. And so you'll see that the authority is basically required by statute to distribute 15% of the funds that it receives to participating localities. Another 35% of the funds are to go to regional partnerships, which basically can be any partnership of at least 2 participating localities that are within the same Community Services Board region. In addition, 15% is specifically to go to state agencies, and then the remaining 35% is unrestricted. So that means it can go to participating localities, it could go to regional partnerships, it could go to state agencies, and it also can be used for the administrative expenses of the Opioid Abatement Authority. So you'll see that with regard to the money that's going to be distributed by the Opioid Abatement Authority, up to 85% of that is potentially available for participating localities. Now, it will be a little bit less than that because of administrative expenses. But we think that the allocations under the MOU are very, very favorable for localities. Also with us today is Ed Spivey, who's one of the outside counsel for litigating localities, and Leo Rogers. And I just wanted to see if they have anything they would like to add about the MOU.
Rich, thank you very much. This is Ed Spivey, and I wanted to first just thank VACO and VML for the opportunity to attend this and to be invited to speak. I thought that covered things very well, just so that everyone sort of understands how this real cohesive team sort of rounds out. My firm, along with co-counsel at Sanford Heisler Sharp and the Sakala law firm, represent a little over 60 Virginia localities in pursuing litigation claims against these distributor defendants. And Jansen Our team was the first to file suits here in Virginia against these defendants. We're joined on this panel as well by Burton, LeBlanc, and Aaron Hara, who were part of the team that's very involved in the federal multi-district litigation against these defendants, which I'm sure you've all heard of. And I think at this point, I'm going to talk to you a little more about the details and the minutiae of how you participate in these settlements. But I would just like to say that that we have gotten here through years and years of both litigation effort and discussion and negotiation between local government interests and the Commonwealth's interests represented by the Office of the Attorney General. From my standpoint, we have developed a very constructive partnership that is good for Virginia as a whole, both the Commonwealth and all of its constituent local governments. At this point, and I think Rich alluded to this, over half of Virginia cities and counties have already formally approved the memorandum of understanding that has been discussed. And that represents a little over 70% of Virginia's population. Many of those jurisdictions have already approved these distributor Jansen settlements that we've been discussing or have it on calendar for approval in the very near future. And the whole object of this presentation is, to make sure that particularly non-litigating localities who have all of a sudden been informed of this and are sort of getting up the learning curve as quickly as possible, have as much information at their fingertips as possible. I am here not to provide legal advice. I've got plenty of clients who I'm doing that with. This is not a promotional piece in any way, shape, or form. It's educational. And so I just want to make sure that everyone on the call realizes that. And with that, I'll turn it over to Tom Beshere, who I think is going to lead the group initially through this issue of how you participate in this MOU and these settlement agreements.
I think actually we're going to have Tim talk about the Opioid Abatement Authority first.
Very good. Thank you, Rich. Tim, why don't you take it from there?
Will do. I'll be very short. If I could have a point of personal privilege, first of all, to thank everyone in the Attorney General's office and with Ed and other local governments, governing bodies who have worked together to get the Commonwealth of Virginia where we are today. I believe these folks have been rather humble in the role that they've played. Commonwealth of Virginia is currently a leader in the opioid litigation, and part of that is the Opioid Abatement Authority that is codified in the Code of Virginia. As Rich had mentioned before, 55% of all proceeds from the settlement of these opioid cases is going to come to the Opioid Abatement Authority. You will see here a listing of the board of directors, and I am fortunate enough to have been appointed by the governor, was nominated by my peers in the local government attorneys of Virginia, and then selected by the governor. There are 5 local government representatives on this board of directors. And it is by Virginia Code under, if you just want to know the code section, it's Virginia Code section 2.2-2367. That sets out the requirements of the board and who will be appointed. You will note that we have a member of the Sheriff's Office, Director of Clinical Services from Piedmont Community Service, myself as a local government attorney, and then we also have an Executive Director, Daryl Washington from Community Services Board, Fairfax County, and then of course we have the Honorable James Holland who is the chair of Chesterfield County Board of Supervisors. Now, this board is not only already appointed, we've already had a meeting. Next slide, please. We have a meeting, held our first meeting on October 5th, where we did a few organizational matters, including the initial review of bylaws, and we'll be meeting again on November 8th, 2021, in order to review these bylaws, finalize them, and election of officers. As was also mentioned, we currently have, since the Commonwealth of Virginia was so gracious, we already have some funds in the Opioid Abatement Fund as a result of prior negotiated settlement by the Attorney General Office. And the decision was made that 100% of those, as you heard from Rich, 100% of those funds were placed in the Opioid Abatement Fund. Now, to increase and maximize the amount of money to everyone, it requires participation. And that's where Tom Beshere is going to come in and tell you how we need all localities to participate. So Tom, I turn it over to you. Thank you.
Thank you. So I'll start by reiterating something that both Rich Schweiker and Sam Towell, I believe, alluded to earlier, which is that in order to participate, it will require joining both the Virginia Memorandum of Understanding and the settlement agreements themselves. And as I believe Rich noted, about 80 or so localities have already joined the Memorandum of Understanding. So we're already well on the way to achieving very good, complete participation in that Memorandum of Understanding. To participate, a locality will need to adopt resolutions to join both the settlements and the Memorandum of Understanding. And we're asking that once those resolutions are adopted, that copies of them be sent both to us here at the Attorney General's office and to Ed Spivey at Kaufman and Canoles, who has been working cooperatively with us in the Attorney General's office to help kind of shepherd this process along to obtain as much participation as possible, which will allow the Commonwealth to maximize its recovery under these settlements. Once that is done, then you'll need to actually join the settlements themselves and to submit the required documentation in order to join the settlements themselves. To do that, I think we can go to the next slide, please. Okay, well, that's about joining the, that slide reiterates joining the Virginia Memorandum of well, actually go back, yes, go back to that in step one for a second. One thing noted on this slide that I forgot to mention is that if you would like, we can provide model language or suggested language for a resolution for the localities to consider in joining the Memorandum of Understanding. And then down at the bottom on this slide, it's providing my email address and Ed Spivey's email address to send copies of your resolutions to us once they are adopted. All right, now we can go to the next slide. Yes.
Tom, we're posting all of those documents in the chat at the end of this session here.
Okay.
So they'll have them. Okay.
Great, thank you. All right. And so as far as signing on to the settlement agreements themselves is concerned, again, first, the locality will need to adopt a resolution approving the settlements and providing authority for a responsible officer to enter or execute the settlement agreements on the locality's behalf. Then you will need to go to the website that is indicated in the slide here. It's nationalopioidsettlement.com, and register with your assigned registration code in order to with the settlement website, which is administered by the settlement administrators. Letters should have gone out already to all of the Virginia localities containing, in essence, containing many of these same instructions that I'm going over right now for purposes of participating in the settlements, and also providing for each locality a unique registration code that it can use when you go to this website to register. We have heard from some localities that for one reason or another, they did not receive a notice letter yet, or don't have their registration codes. And if that's the case, there is an email address you can use to request your registration code. It is registration@nationalopioidsettlement.com. And if that doesn't work, then please let me here at the Attorney General's office know, and we will reach out to the multi-state leadership and the settlement administrators to try and unstick whatever issue might be preventing or oversight might be preventing a particular locality from getting its codes. Like I said, we have heard from a few localities that they haven't gotten their registration code or haven't gotten a notice letter yet. We have, in a few cases, been able to run that up the flagpole and get that information for the localities. But if there are any localities out there that are still having that problem, please let us know, and we will do what we can to move that process along. When you go to register, you'll be asked to go back once to the, thank you. You'll be asked to provide the contact information for the person who will be authorized to execute the formal settlement documentation. And then once you receive the documentation, you'll be able to use the DocuSign service to actually execute the settlement documents. And included in the settlement documentation will be language in which the localities, because this is a settlement that you'll be joining, will be agreeing to release any current or future opioid claims against these distributors or Jansen. And that is the scope of the release is also spelled out in the settlement agreements themselves, which are available on the National Opioid Settlement website. That is the logistics of how to participate and sign on to the MOU and the settlement agreements in a nutshell. So we can go to the next slide now. And this is a key point to remember in order to maximize the amount of settlement funds that will flow into the Commonwealth, both for the localities themselves, for the state, and for the Opioid Abatement Authority. We need to have maximum participation from the localities, and the time to complete this process, the deadline for completing this process in order to ensure our maximum recovery is January 2nd, 2022. What's up on the screen right now is an image of the settlement letter, or not the settlement letter, excuse me, the settlement notice letter that has gone out to, or should have gone out to the Virginia localities. I know many have received this, as I noted before. There are some who have indicated that they haven't received it yet. If you haven't received it and haven't received your registration code to be able to go to the settlement website and register your locality and receive the settlement documents to execute, please let us know, and we'll do what we can to get that information for you.
Tom,
Yes.
let me just for everyone's benefit, let me just chime in here and sort of frame this, because I know we've got a lot of folks on this call, which we really appreciate. The subdivisions that should have received this notice of settlement are every city and county in Virginia and a small list of towns. If you're a town on this call with populations below 10,000, don't be alarmed. You should not have received this notice of settlement, and you're not missing anything. I can quickly list the towns that should have received this notice of settlement. It's Blacksburg, Christiansburg, Culpeper, Front Royal, Herndon, Leesburg, Purcellville, Vienna, and Warrenton. If you're a town on this call and not on that list, do not, you don't need to worry about having not received this notice, and you do not need to go through the steps we have been discussing. If you are a Virginia city or county, or amongst those 9 towns, you should have received this notice of settlement that is up on the screen now. We just looked at the first page of that. This is the second page of that notice, and this contains one really key piece of information. It's highlighted here, your unique subdivision identification number to use to register is, and each one of the notices that went out should have contained that unique subdivision identification number. And when you go to register your jurisdiction for these settlements, you will need that unique identifier. As Tom mentioned, if we could go to the next slide. If for some reason you are a Virginia city or county or one of those 9 towns and you have not received a notice of settlement with that unique identifier, there's an easy way to get it. This is the email address you should email: registration@nationalopioidsettlement.com. Identify yourself as representing your particular jurisdiction, and that email is being monitored daily, and you will receive that unique identifier number back very quickly. I've tested it out and it works. This is an important email address to copy down or to have if you have not received that notice of settlement with your identifier number. We thought it would be helpful, and if we'll move to the next slide, please, we'll start this. We thought it would be helpful to just lead everyone through what this process is. It's very basic, it's very easy. Once you go to www.nationalopioidsettlement.com, these are the few steps you will need to take in order to navigate to both the Virginia MOU and the settlement documents, the participation agreement that is required to participate in these pending distributor Jansen settlements. So when you go to the website, you will see this screen, and you'll see right up front in yellow, this is highlighted on the actual website: subdivisions register here to receive participation agreements for distributor and Jansen settlement agreements. We're going to come to that, but before we do, I want you to notice on the right side of the screen, under state-specific documents, you will see Virginia listed amongst that minority of states that have gotten to the point that we're at now, which is to already have a memorandum of understanding in place. So if you go to the next slide, please. When you click on Virginia under those state-specific documents, it will take you to this screen, which shows allocation deal-Virginia. And when you click on that, next screen, please, you will see it brings up the Virginia Opioid Abatement Fund and Settlement Allocation Memorandum of Understanding, what we've been referring to today as the MOU. This is just the first page, but on that website, you will see the entire MOU with signature lines, with all exhibits, etc. So if you're wondering where to go to find the actual MOU, It's www.nationalopioidsettlement.com. And then with a few clicks, you will arrive at the document. Next
Hey,
screen, please. Yes.
Hey, Ed, we have a question in the chat dealing with towns. If you'll look there, it's from Jess Arena. Question is, so towns have to independently approve of the MOU and the settlement rather than relying on their county's approval. Is that right?
That is right with regard to the 9 towns I listed. The 9 towns will need to approve the settlement with Jansen and the distributors, not the MOU. The MOU applies to Virginia cities and counties. The settlement, however, requests the participation of those 9 towns. And if you're not amongst those 9 towns, you don't need to do anything with regard to these pending settlements or the MOU.
Ed, one further question before we get too far down the road. Is there a central point where counties and cities and towns can submit everything and then work with the OAG or work with someone if there's anything missing by the January 2nd deadline?
Yes, yes. And let's break that down into 2 pieces, Dean. Thanks for that question. First of all, the Memorandum of Understanding, the MOU that we've just seen how to navigate to, and that has already been signed on by many, many cities and counties. Those cities and counties that have not yet formally approved the MOU need to get it on their governing body's agenda for approval. And once it's approved, one of the earlier slides that Tom Beshere showed you shows Tom's email address and my email address. And if the city and county that approves the MOU, the non-litigating cities and counties, when they approve the MOU, if you would please email those resolutions, those approved resolutions to both Tom and me, we are keeping track of those. Now, with regard to the settlements, we're about to come to the answer to that question, Dean, with regard to the distributor Jansen settlements. Let's go to the next slide. There we go. So again, this is the screen that you will see when you go to www.nationalopioidsettlement.com. We've just shown you how you can navigate through this website to get to the MOU. Now we're going to talk about how you use this website to register for participation in the distributor Jansen settlements. And again, it starts with that highlighted box. You'll click on that and it'll take you to, next slide, please. It'll take you to this screen. Subdivisions register here to receive participation agreements for distributor and Jansen settlement agreements. And it's very easy. All you have to do is put in 3 pieces of information: your state, the name of your political subdivision, and your registration code. You'll remember we looked back at the notices of settlement that were sent out, and we showed where that unique subdivision identifier could be found. And if for some reason you don't have it, we showed you that registration at nationalopioidsettlement.com email address to email for it. This is where that unique identifier goes in that registration code box. And one other thing I'll tell you, both the state and political subdivision boxes are auto-populated. And so if, for example, I'm sitting here in the city of Norfolk, if I just put in Norfolk, it might not take it. You might have to put in city of Norfolk, but you will see some drop downs and very easily ultimately identify your jurisdiction. Put in your state, your jurisdiction, and then that unique registration code, and then you hit verify registration code. And that'll take you to the next screen. All right, and here is that next screen. subdivisions register here to receive participation agreements for distributor and Jansen settlement agreements. First of all, registering to participate in the settlements is something I would encourage every jurisdiction to do today. It does not commit you, your jurisdiction, to participate in the settlements. It merely registers to you to receive the documents that will ultimately be needed to participate in the settlement. So it would be advisable to go ahead and register immediately, and then your ultimate election to participate can await action by your governing body. Once you've registered, this is the screen you're going to see. And again, it asks for just a very few pieces of information, including the identity of the person who this website is interacting with, the identity of the person who will be authorized on behalf of your jurisdiction to participate, and if you choose to participate, whether you will do so via DocuSign or paper signature. And we highly encourage that you elect that DocuSign feature. As has been emphasized several times already, and I'll repeat the emphasis, January 2nd, 2022 is our deadline. We need to have all cities, counties, and those towns that I mentioned have navigated through this process and be in a position to participate in the settlements if it is their desire to do so by January 2nd. And being able to do it ultimately via DocuSign, I suggest, will eliminate a lot of headaches for everyone, including the participating locality. I think I'll close. Hopefully that's helpful. I haven't shown you anything that you won't see when you go to www.nationalopioidsettlement.com. I think you will very easily be able to navigate through this process. I would just close with one last encouragement. These settling defendants are big businesses. They're not political subdivisions of the Commonwealth of Virginia, and they don't necessarily appreciate that there is a process that any subdivision must go through in order to enable it to participate in these settlements. You've got to get this on your governing body's agendas. You've got to get your governing body to approve these resolutions, and then the ministerial acts of participating come at the tail end. But we're approaching the holidays. We've got a hard January 2nd deadline, and we all know that governing bodies don't act from 1 minute, much less 1 day to the next. And so it's essential that that you begin to pay attention to this, to get it on your governing body's agenda as quickly as possible, and to have them act on the 2 resolutions, form resolutions that are now on your screen, and that VACO and VML will be distributing for your use if you choose to use it. Those 2 resolutions are separate. One approves the Memorandum of Understanding. The other one approves participation in the distributor Jansen settlements. And that should be at least a form, a beginning for everything your jurisdiction will need to memorialize that governing body decision, hopefully to participate in these settlements. So register now, get it on your governing body's agenda, and deal with it just with as much alacrity as possible, so that for the good of the Commonwealth as a whole, we collectively are in a position by January 2nd to participate. With that, let me hand it back over to Tom Beshere, who I think will conclude us. And Tom, yeah.
Thank you. I had to take myself off of mute. Thank you, Ed. I think that pretty much covers the bases in terms of the logistics of participation, but we wanted to leave some time and opportunity here at the end in case anybody had questions. We expect that there probably will be questions, and not just today, but in the coming days and weeks as well. And so we are here to try and address and resolve any questions you have as best we can.
Hey, Tom.
I'm
Tom,
sorry,
Dean Lynch.
go ahead.
Yeah, Dean Lynch here. Hey, we have a couple questions in the chat for our panelists. The first question is, will we be able to change the authorized signatory at a future date since positions may change? Can anyone answer that?
That's a good question. I believe so. It's not one that that has come up yet, and it's one that I can certainly raise on the next call that I have with the multi-state group. I'm sure that is something that can be done, just because, as you indicated, people come and go in different offices and different responsibilities. So it might be the fact that there's a change in personnel at some point in time in the future, and the responsible person in your office might need to be changed. So we can certainly raise that and get back to you with a definitive answer on how to do that.
Another question I see in the chat is, if a locality itself, by way of the county or city attorney, has already registered on the National Settlement website, if outside counsel then goes in behind to double check by attempting to register the locality, will the website show that the locality is already registered? i.e., can you register a locality twice, or once a locality is registered, it will show as if someone else tries to register it again?
As far as I know, it should show that the locality is already. I don't think it would allow you to register twice, but again, that's not something that has come up yet. So Ed, is that an issue that you've had to address?
No, it's not, Tom, but it is worthy of a little clarification. If you are a litigating city or county on this call with outside litigation counsel, your outside litigation counsel either has or will register you. So if you're represented in opioid litigation, you should not proceed through those registration steps. Those steps are required of Virginia cities and counties and those 9 towns that do not have outside litigation counsel.
And just to add one other note to that, for localities that are litigating and are represented by outside counsel, a copy of the notice letter should have gone to the locality itself and to their outside counsel. The outside counsel separately should have received a copy of the same notice letter.
Tom, were those notices in the U.S. Postal Service or email or both?
As we believe, as far as we can tell, both. They've been, because I know that some localities that we've been in contact with have indicated that they did receive it by email. And when we provided contact information to the multi-state leadership and the settlement administrator, the contact information that we provided included email addresses. Now, in a couple of cases, we have since learned that email addresses that were provided were either outdated or not correct, and we've had to go back and correct them so that the correct people could get the notice. But it's my understanding that the notices are going out by both mail and email.
You know, another question we've got in the chat regarding registration is, if we were registered online, how long before we receive the documents that need to be signed? Does anybody have any idea?
That is a very good question that I have asked myself, because if you were to register right now, you would not receive the participation agreement back immediately. My understanding is that is this is all within the province of the settling defendants and the national administrator, the settlement administrator, and certain of the AG leads. But I believe that should be forthcoming in the near future, but I don't have a date. I don't know, Rich or Tom or Sam, if y'all do. I don't know a date specific when that should be expected.
I don't know a date specific either.
Do have one more question in the chat from a county attorney, and it says, as legal counsel to our jurisdictions, it appears that we must be satisfied as to the factual basis to the allegations against the defendants in the litigation, which resulted in the settlement, and to share that with our governing bodies. Where do we get that information?
Well, there is, in the case of Virginia, the Commonwealth of Virginia has not actually filed litigation against the distributors or Jansen. There were some other states that did. There were some other localities across the country that did. That resulted in a process in which the distributors and Jansen essentially brought all the states together to try and obtain global peace. So the settlements involve both states that were litigating and states that were not litigating. I would say, though, that a good primary resource for allegations that have been made against these distributors and against these Jansen are the complaints the complaints that have been filed by litigating localities in Virginia. There are some localities that have litigated against these entities, and the complaints that have been consolidated in the opioid multi-district litigation in Ohio. That's probably the best resources to look to get a feel for the allegations that have been made against these companies.
And if it would help that the person who posed that question, because it's a good one, we're happy to supply an example complaint. They're public documents. We're on file in 60 different Virginia circuit courts, and they certainly lay out the alleged facts against these distributors in Jansen.
I have a question moving forward, but before I ask it, I just wanted to let everybody know that the slide deck and the sample resolutions, there is a link in the chat if you want to access them before we end the call. You can do that. My question is, moving forward, what will be the procedure if other defendants seek a settlement?
I'll take a crack at that. It will depend on whatever the terms of the future settlement are. Although I imagine now, because we kind of have this infrastructure in place for these major opioid settlements, that future settlements will probably, in some fashion or another, follow similar procedures and perhaps even piggyback on the procedures that are being used here. But it would be speculative at this point to try and divine what that would entail.
Are there other questions?
So Dean, if I could make a couple of points and if allow folks who might still be formulating questions to put them together. We've really been emphasizing the importance of getting all of our Virginia counties and independent cities on board, as well as the towns that Ed mentioned. And just want folks to understand that when we reference that up to 530 million, that's really based on the level of participation, because the three distributors and Jansen, it's all in their interest that they want these settlements to end these matters. So they want to get everyone who could possibly conceivably sue them, whether they might sue them or not sue them, on board and to sign on to the settlements. And because of that, there are gradations as to how much each state and its localities will receive. And that's why, so from a Commonwealth-wide perspective, it's very important to get everybody on board. It's also important, though, to the individual localities, to the counties and independent cities, because you will not receive the funds, any of those that are designated specifically to go to localities, if you do not participate in the settlements. And you also will not be eligible to receive the funds from the statewide Opioid Abatement Authority, because by statute, those are available to participating localities. So just want to folks to appreciate that. And this is a long-term situation. This epidemic has been with us for a long period of time. And you've seen that there's an 18-year tail on one of the settlements. So there will be money that will be coming in over a number of years down the road, as well as the money that will be distributed by the Opioid Abatement Fund, and would hate for any localities to miss out on that opportunity to receive those funds because they don't take the steps now in the next couple of months to do so.
Now, I think we do have one more question in the chat. I think people just want to be clear. The participation agreements and MOU will be sent at some point between now and January the 2nd.
Let me try to address that, Dean. I see it in the chat. So there are two documents. One is the Memorandum of Understanding, or the MOU, and the other are the participation agreements associated with the Distributor Jansen settlement. The MOU is available right now at www.nationalopioidsettlement.com by navigating with a few clicks, like we did earlier. It's available, the entire thing is there, and your jurisdiction can act on that immediately. The settlements with the distributor and Jansen, you can register to participate in those settlements. You can put those settlements before your board or council on their agenda immediately. And the only thing that's not yet available with regard to those settlements are the participation agreements, which it's my understanding will be a 2 or 3 page document that simply acknowledges the jurisdiction's participation in the pending settlements. Those are not yet available, but will be sent to the individual who registers a jurisdiction at some point in the future that we don't know with specificity. But the MOU is there, available as we speak. The actual settlement documents, which are hundreds and hundreds of pages long, are on that website. Registration is available now. The only thing that's not yet out there is that participation agreement that will be coming sometime in the relatively near future.
Another question regarding the authority, the abatement authority. I think it's someone wants to know. It says if we do not join the MOU now, then we cannot receive aid from the abatement authority at a later date. Is that right? Is the OAG around? Ed, can you hear me?
Yes, I can hear you. I was waiting for the OAG, but that's correct. The legislation that was enacted earlier this year requires any jurisdiction that wishes to participate in the funding that will now begin to flow to participate in both the memorandum of understanding and the settlements that are now available in relation to the distributors in Jansen.
Looks like one final question is, does the resolution become a part of the MOU? And is this how we agree to the MOU?
The form resolution is the expression of the governing body authorizing a designated county or city representative, whether that be the county attorney or the county administrator, city attorney or city manager, to actually execute the memorandum of understanding. So what we would ask is that when your body approves it, you send Tom Beshere and me a copy of the resolution and a copy of the signature page.
All right. I think we'll go ahead and just let everyone know that we will be hosting all this stuff on our website, the VACO website. We will have a recording of this. We can also send out any information, additional information upon request. So give us a chance to, I guess, download this to our website in the next day or so, and feel free to share the information with those that are not on the call or couldn't get on the call. I want to really thank our panelists for being a part of this. Ed, the Office of Attorney General, our local government attorneys, Leo and Tim, thank you all for being a part of this. I do wanted to quickly mention that Terry Kilgore was supposed to be on the call too, but he texted me and said that he had a medical issue with one of his family members that he was having to deal with. So totally understand that. So, but wanted to let you all know. Anything else, Ed? Anything else that anybody last thoughts?
Not from me, Rich.
I'll just say, I see there's a question. There's one more question, and I don't think this was addressed about, is there any lower number just for reference if less than everyone participates? So I'll just say that the settlement agreements are extremely complicated, and there are various thresholds depending on which subdivisions join or localities join or don't join. Part of that's based on their population. Part of that's based on whether they're litigating or not litigating, and there's different incentives or bonus structures. So can't really give you a number of, well, here's how much the Commonwealth would get based on if this number of jurisdictions join or do not join. So there is a lower number, but certainly we don't want to be in the lower number category. And just long term, we think it makes sense for everybody to be a part of this. And I would also say that one thing to think about too for maybe some of the smaller jurisdictions is that if you recall, the Opioid Abatement Authority can distribute money to regional partnerships. So that's something that might be appealing to think about, being able to partner with others in your community service board region. If you're thinking that, well, my share might be really small, but you can collaborate and work with your neighbors and partners in a way that could enhance how much you might be able to have come to your community.
And Rich, this is Tim Spencer. Just to make clear, in order for Virginia to maximize its receipt of these settlement funds, 100% participation is what our goal should be, correct?
Absolutely, because we there's this money there, and we want it to come to Virginia. We don't want it to go elsewhere. We don't want to miss out on that. And so the easiest, simplest, most prudent and advisable thing for us to do is to get everybody on board and everybody do it by January 2nd. And that's really for the good of the Commonwealth, for the good of litigating and non-litigating jurisdictions. Really, really important. This is a much more complicated settlement than we typically had in the matters that we handle. But as Tim succinctly put it, that's the goal, that's the desire, and it's not like we really won't be happy with not meeting that goal. Basically, I don't think anybody will be happy if we don't meet that goal.
And
All
if
right.
I remember, Ohio has already reached 100% participation. Am I correct?
I am not certain of that. I don't know if Ed knows that, and I'll say that unfortunately Tom's computer shut down on him, so I'm not sure if he's back on yet or not. He might have the answer.
I believe they did, and I just don't want Ohio to beat Virginia.
I think Tim's right. I think Ohio is the only state in the country that has met that threshold as we speak. Virginia is one of a very, very small number that are right behind. And we're poised, I think, to meet it by January 2nd if everybody gets on board, which I think, again, we'll circle back to VACO and VML, could not have been a more timely and appreciated forum for this information to go out. I know I'm not alone in expressing my gratitude for that.
Well, thank you to the panelists on behalf of VACO, VML. We really appreciate this. Some great information going out to our local governments. And thank you all for being the experts on the call today. With that, I think that we will close. Thank you all.
Thank you.
Thank you.
Thank you.